Impact of Influence.
Covering true crime throughout the Southeast.
Hello, friend. Matt Harris and Seton Tucker always gratefully spending time with us. You can go to Facebook, Impact of Influence. From there, you can get the YouTube channel as well. A lot of new subscribers. Super happy about that. So please subscribe, rate, and share the episodes. That would be much appreciated. We're going to be dealing with Myra Crosby and her story in this episode and the various filings. We're going to talk to her current attorney, Joe McCulloch, in a moment. Myra, known as the egg juror, 785 too, and you had a comment someone made on this.
Couple comments on our last episode. Becky wanted to point out that the claim that the egg juror didn't write her book for fame and fortune because it was self-published on Amazon is kind of ironic because those were the same claims about Becky's book.
Oh, like not us, but others had said.
Fine on that, but yes, I think the Dick Harputlia and the defense team said that their theory was that Becky was...
She wanted guilty because that way it helped her book and help her get rich.
Right. And former Chief Justice Toll did say that she believed that I think Becky was seduced by this siren call of celebrity or something.
Right.
Along
And
those lines.
and you could do something to become celebrity versus being rich. Two different things.
That's true. They're different things.
I don't know the motivation for Becky. I don't know the motivation for Becky. It appears to me the motivation, it doesn't mean either person's lying. Even if the motivation is money, doesn't mean it's a lie.
Exactly.
In Becky's case or in this case. So I think she really wants her story to be heard.
I do too. But again, we're not telling anyone what to believe. Make up your own. Also, the same person commented that she didn't buy Myra's claim that she saw the four-person go off and talk to Becky because of the time frame, and it didn't match up with when Judge Newman interviewed her. But I was able to confirm that Judge Newman did talk to the egg juror several times in chambers,
not just that one,
not just one time.
The one time she was referring to the one time where she actually got the boot.
Right.
There was other times.
There were other times.
Okay. All right. Clear that up right away. That's what we do here. We try anyway. So fire away your question to us on Facebook. And by the way, before we get to Joe McCulloch, Myra's attorney, you ran into a big famous person at the USC Gamecock game.
Oh my gosh, it was so funny. We were sitting during halftime getting some concessions, and my husband looked over and said, "There's Judge Newman." And I thought he was kidding because he likes to tell me he sees celebrities all the time. And I'm like, okay, yeah, right. One time we did see Carrot Top. So I just went up to him. I said, "Can I get a picture?" It was so cool. Like I felt like I was seeing a celebrity.
You sent it to me right away.
More of a celebrity than Carrot Top to me. But
that's good.
Carrot Top was pretty cool. He's very, very nice.
So Myra Crosby, she wrote the book. We had her on. We'll put it in the show notes exactly what episode that was. Her attorney is Joe McCulloch. She wants various things released that are under seal right now by the government, like in-camera things that were done in chambers. She wants everything released. I don't know if they got specific in this latest thing. We'll ask Joe. But the interviews that were done by SLED with her tenants, who were the ones that SLED claims said she was talking about the case, which is one of the big reasons she got kicked off.
Right.
So now we have new rulings on that, and Joe McCulloch has filed another brief or filing on behalf of Myra Crosby. Let's talk to Joe. He is back, the lovely and talented Joe McCulloch. Hello, Joe.
Howdy, guys. I'm always glad to be back. Hell, I'm anywhere.
You're glad to be anywhere. Yeah, I can imagine. You represent Myra Crosby, who we've had on the air before. She's also been referred to as the egg juror, and she was the juror that was kicked off the Murdaugh jury just hours before they were going to deliberation. And so this has been going back and forth onto what will be released, what will not be released, and that is up to the government. And so take us to where we are now. Has it gone to the Supreme Court, Myra's case, where she wants things released?
Yeah, let me say this. She has been known variously as the egg lady, the monkey lady, because she worked at the monkey farm, and oftentimes as juror 785, I think.
Yep.
all of that to genericize her and to preserve her anonymity and privacy. That's only relevant to this discussion because we're referring to her by name, Myra. And that's because she's now published a book that is on sale on Amazon. And I'm sure that your viewers, if they're interested in reading one of another, this must be the 10th book in the series, but it's just one of those subjects that's captured a lot of imagination. So in any event, having said that, I am ethically able to refer to her by name, which I would not otherwise be able to do. So to go back to the point of our talking today, more than a year ago, as I was representing and have been representing Myra since shortly after her removal from the jury, as you say, hours away from the entire case being given to the jury panel, who had sat there like Myra for 6 weeks of evidence. Hours away, she was removed. Now, that removal was in the context of the judge saying that he believed there had been some type of communications that she had not done anything wrong, but he felt
Right.
that she needed to be removed. And that decision and that announcement in open court was kind of a lightning bolt to a number of people who had been watching the juror, students of juror body language and English. And it also was preceded by several days of backstage discussions among state and defense counsel, the judge, and other witnesses who were presented. When I call it backstage, we call it more technically in-camera proceedings. So more than a year ago, to discharge my duties on Myra's behalf, I filed a motion that was consented to by the state and consented to by the defense for the release of those in-camera backstage proceedings, transcripts, information, evidence, whatever, so that I could evaluate that and advise my client. As a result of having seen all of that, what there is, I can't really talk about it because it remains today under seal. But the court back then, more than a year ago, agreed to the release of that information for our exclusive review, but said that it was not to be publicly disseminated, not to be shared with the public. That was all right at the time. Subsequent to that, there had been a number of attacks by media people who call themselves journalists, and some of them have been really crude, cruel, and frequently off the mark. And I think the record needs to be set straight. And so I filed another motion several months ago with the Supreme Court after the state Supreme Court had taken it away from the Court of Appeals. They, as you know, have taken the murder conviction appeals, of which this juror removal has now become a rather pivotal issue. And the Supreme Court has taken it over for their ultimate determination on the issue of new trial on one of many grounds the defense have stated. I went back to the prosecution and said, I'm filing a motion with the Supreme Court to unseal these records for public discussion and dissemination. I happen to believe that secrecy is, the enemy of democracy. It's the enemy of justice. It's the enemy of public understanding of this murky stuff we do across the street in the courthouse.
And I can interject for a second. One of the reasons they said that they didn't want to release it was her anonymity. That's important to point out because now that cause to keep it sealed is gone.
Well, you're correct, Matt. In fact, that was the only announced reason for the sealing of the records, to preserve the anonymity of the jurors, as the court transcript states. And I feel some license to say that, even though that is a part of the record backstage. But that I have said in this most recent motion, that because Myra Crosby, the only juror discussed in those backstage proceedings, she's the only one with any anonymity, confidentiality concerns, and she's willing to waive and relinquish them and by my filing. So with that,
Do you think that the reason that she wants these released is basically to clear her name, since there's been so much negative press about her?
well, I think that's in part, but I think that what the public has is an incomplete understanding of this entire process. And I think what she believes is the public has a right to know how this whole thing unfolded. It does bear on the propriety of her removal. It does serve a record straightening, perhaps a record straightening ability, but I think it is her genuine belief that the public is interested, and everybody ought to have the benefit of what she and I know and the other participants in the backstage proceedings. But it was interesting to me that the prosecution suddenly opposed unsealing the records. The defense continues to believe they should be unsealed and joined or didn't oppose my motion. And the Supreme Court then released a one-sentence order, basically, that said the request of petitioner, that would be me, was denied. So
No cause, just a sentence like that.
just the sentence, just the finding. And
Does this have anything to do with the ethics investigation into former clerk of court Becky Hill? Because I know her ethics investigation hearing has been delayed, and that the AG's office is now saying there's some pending possible criminal charges. Do you think that maybe keeping these records sealed has anything to do with that?
well, I think if you filed an FOI right now for the investigative records at SLED or at the Attorney General's office, since they're presiding, they're the prosecuting authority over the investigative authority, which is SLED, that the answer to an FOI would be that this is a matter in process and under investigation. But from my standpoint, that's not really the Supreme Court's function to protect the investigation. But if that is the explanation, if ultimately my latest filing, filed November 15th, today's the 19th, I have asked the Supreme Court to provide some explanation. I mean, the Supreme Court has the lawful authority to do anything they wish. So this is not a challenge to their authority. It is simply my request that they consider this one sentence order denying it and provide a basis for that, so that if I determine to appeal this above and beyond the South Carolina Supreme Court, I'm not challenging their authority to do whatever they want to do. I'm simply asking for an explanation that will allow me to go forward, if I choose to do so on behalf of my client, and that would be her decision, to seek further relief, be it at the in the federal courts and perhaps the United States Supreme Court.
Okay, let me ask you this, just in a general sense. Is the in-camera stuff in a general sense, is that public? More often than when any regular murder case or something that we don't know, like Murdaugh, there's no one famous. Is that, if I were to go and file a FOIA request for a random murder charge in South Carolina, would I get everything?
Well, yeah, probably. Well, it depends, but the answer to that is a qualified no. And there are certainly, in my experience, and I sound like a broken record when I say I've been at this almost 50 years, but I am rode hard and put up wet in the justice system. I've been a prosecutor. I've been a defense lawyer. I've been in cases where records were sealed and unsealed. I've been in cases where records remain sealed. Some of the justifications for that secrecy can include things like witnesses, a victim, let's say, who's got a right under certain circumstances, especially if they're an underage victim, they have a right to continuing privacy and secrecy about their identity. There are other situations, drug cases in particular, I've seen it, where our state and federal courts have required certain aspects of evidence, be it in court and out of court, to maintain the secrecy, the anonymity of a cooperating witness until they get them in witness protection or otherwise protect them from potential harm.
There's no one being protected in this case
There is no one to protect
that
them.
we know of. I mean,
Well, certainly the reason for sealing was to protect the confidentiality of the very person who's now moving not to be protected. To have
do you say like specifically what you want in the thing? Like, for instance, you want the in camera that was the meet, or you're just saying everything, or is it like the in camera when she went back there and was questioned by Newman? Are you asking for the
Transcripts of the SLED
SLED interview?
with the,
Yeah.
with the her
well,
tenant.
in a public filing before I filed my first motion, I ran across an exhibit list of the documents and things that were sealed, and they include ultimately a transcript of the proceedings, because all of the in-camera proceedings were recorded by a transcriptionist, a court reporter. There are also statements, there are emails, there are recorded interviews conducted by SLED, which we've now transcribed those, but we cannot release them. So there's a lot there to go through, to unpack, as somebody.
I mean, but you don't list specifically what you want. You just say unseal everything.
I think in the previous motion, I did list what I wanted. I'm not sure that that's articulated in detail, but I think that everybody knows what I want.
Right. Now the latest South Carolina Supreme Court Justice was it
Kittredge.
Thank you. One of his first statements upon being sworn in was that transparency. I'm sure you saw that quote. That transparency was going to be first and foremost one of the things that he was going to help change about South Carolina, which I found very interesting. But that was his statement, right? Am I correct on that? That was one of his things that he wanted to push.
I have the utmost respect for our new Chief Justice. I am looking forward to wonderful achievements by him. But I do recall that he expressed at some point that he was very much in favor of transparency, which is not to say in this situation, the court has considered my petition. They have discussed it, and they have a logical reason and basis for not unsealing. It may be that they feel that to unseal it might jeopardize one of the witnesses or some of the people involved in those proceedings. It's difficult for me to see that, but my latest motion filed last Friday is simply to ask them to articulate, even if it's in a guarded fashion, tell me why.
Yeah.
And I think I'm permitted to do that. I certainly did not file this to challenge the court or their decision to deny, but I think I'm entitled to have a better understanding of the why. And so we'll see what happens from here. But gosh, the public has enough suspicion and cynicism about our government and about our system of government and about our process. And there are a lot of reasons in the current situation, in this case, to be a little cynical. I mean, I have to say that I am concerned that the two government agencies who are fighting the hardest to maintain and prop up this conviction of Alec Murdaugh are the same agencies that are now opposing the release of these documents. And they have the most to lose, and that is the Attorney General's office and SLED. And I think that prosecutors are challenged, as we challenge him frequently in the Innocence Project area, where we find a case, we dig in and we look at it and we determine that we believe there's a valid basis to assert that it was a wrongful conviction. And sometimes we have to go back to the very prosecutor who convicted that person
Yeah.
and say, we think there's a problem. Can you be open-minded enough
Right.
to allow for DNA testing or to allow for a court inquiry? And sometimes we do and sometimes we don't. But what was an interesting collision that illustrates the problem most graphically is the Alec Baldwin Rust case, where at the end of the day there was a pretty weird hearing, I don't know any other way to describe it, where you've got one prosecutor who was a latecomer to the prosecution, who came forward at the time of the court's consideration of whether they were going to dismiss the case altogether because of prosecutorial misconduct. And that lawyer was saying, look, what the other prosecutor refused to divulge, declined to divulge, I think was a big mistake, an ethical error. And I think that they were wrong. So
Like a whistleblower. It was a whistleblower, basically. Right. Yeah.
in a sense, that lawyer said, I am here to say that there should be a sanction because that prosecutor did wrong. That prosecutor came forward and basically said, oh no, she's a hysteric, she's full of shit, and we didn't do anything wrong. And the court clearly, in the dismissal of the charges against Alec Baldwin, like it or not, found that there needed to be an appropriate sanction for prosecutorial misconduct in failing to release that information. So, I mean, these problems of prosecutors and whether they have the ability to deal with these situations even-handed, even when they have a huge stake in maintaining the conviction.
And the point of the process, the state is always should be right to get to the truth, not to just get a notch in the belt. It should always be about getting to the truth. And the person, the defense, is trying to make sure that a person gets a fair trial. So there's two different things. But a lot of people, oh, you love Alec Murdaugh or this. I'm going to opine for a second. I think if Alec Murdaugh, and it's not really about him, it is kind of, cannot get things unsealed. What about the poor indigent guy who has been convicted and doesn't have the name recognition of the power or the means or whatever?
Or media.
Media.
Yeah.
Yeah. And then can't, you know what I mean? I think it.
Well, Matt, let's be clear. I'm not filing this motion on Alec's behalf.
No. But I'm saying though
Not
that
unsealing it for Alec Murdaugh. It's unsealing it because
yeah,
client wishes it to be unsealed, and because she believes the public has a right to go through the bones of this decision by the trial judge to remove her, and they have a right, she believes, to see that. I join her in trying to espouse and articulate her reasons, and that's what we're up to.
Well, let me ask you this. So let's say they come back with the Supreme Court responds to your most recent filing and says, these are the reasons X, Y, and Z that we did not release the transcripts of all this stuff and all the stuff. Are you going to just take it and say, okay, that's a good enough reason?
Well, it's hard to answer that question until
Yeah, because you don't know.
The reason
You don't
is-
know. But I mean, I'm just thinking, like, let's say, yes.
But
we
I'm a representative of my client's interests and desires.
Yeah.
And she gets to dictate the direction that this effort takes. So if there is the court may not deem my request worthy of any additional information.
Right.
And if that is the case, then I'll have to sit down with Myra and figure out what step, if any, she wishes taken. If there are explanations, then she will have an opportunity to evaluate those with my editorializing or explaining them. And then, as I've said, whether there is a federal appeal, an appeal to the United States Supreme Court, which is possible, I suppose, whether she wishes that much horsepower to be used in support of these requests is kind of up to her.
Mhm.
But
We found her very credible, and her memory of it could either be proven or disproven once the things are released. But it seems to be, more than anything, kind of wants to clear her name, because she's been called, as you said, some pretty vile things by other people in media podcast world who went personal on her, and I don't think that was cool at all. You can disagree or think that maybe she's
Well, there's two things that could happen here. They could say, all right, we need to not release these documents at this time. But then they could say, after this investigation, after whoever is being investigated, that's proceeded, then maybe at a later date that would come out. Is
Well,
that
that certainly is a possibility. I mean, it could be that the court has concluded that with this active criminal investigation ongoing, which I understand includes several allegations against Ms. Hill, but include jury tampering as one of the
right.
components of this investigation. I guess the court may have concluded that this information bearing on that criminal investigation should be sequestered until a later time. I mean, to me, evidence, if there is evidentiary value in the backstage proceedings, it is already known to the prosecution. It's known to the defense. It's known to a number of people. I do not know the extent to which Ms. Hill has been made aware of any of the sealed information, but certainly she was a participant in
She's
some.
there.
And so I don't know how it would give her an advantage if a criminal charge were lodged against her. So I mean, I still.
Oh, there's also, like, if this is released to the media and media runs with it, I don't know, does that affect her right to a fair trial?
I don't know, well, the right to a fair trial.
I don't know. That's not a very legal way to say.
No. That's a very big consideration. And the right to a fair trial comes from being armed and provided all of the evidence.
Oh yeah, true.
Relevant to your prosecution, which includes your ability to formulate a defense, which you can't do without all the pieces and parts of the evidence. But the other consideration that goes to the heart of your statement is the more publicity in this case, the harder it is to pick a jury. You taint the jury pools with bias and information, but gee, it didn't take very long to pick a jury in the Alec murder case. And so I don't really see how the release of information would taint the jury pool with information. God knows, I can't think of a case in recent history that has had more publicity. And the case I can think of might be the Lindbergh baby case. I mean, this one's right up there in the top 10 or so.
Yeah.
That guy out in wherever the hell it is, Utah, that may or may not have killed those 4 women, Conesburg, Colesburg. I mean, that case has gotten a huge amount of publicity, and that a sufficient amount so that the court moved the place of trial to ensure that fair trial. But I don't see in this case, it's had so much publicity already. I don't see this additional information coming out as genuinely jeopardizing Ms. Hill's ability to draw a jury, if indeed she ultimately is prosecuted.
All right, Joe, thank you very much. Always appreciate you.
See you.
We'll probably talk again soon.
I imagine.
All right, man. Thank you, Joe. So grateful you spent time with us. Do appreciate that. Reach out, rate, share the episodes. Go to the YouTube channel, comment on the Facebook page. Friend us, follow us on Facebook. Matt Harris, Seton Tucker, and we'll talk soon, friend.